and unmute yourself. All right. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You may put your hand down. Sir, I understand you are in South Carolina, and so
That's correct, Your Honor.
we've agreed that you are here on Zoom, so you are therefore in agreement that you are not standing next to your attorney. Is that correct?
That's correct, Your Honor.
So if you need to speak with her at any time, let me know and we'll put you in a confidential breakout room, okay?
Yes, Your Honor.
All right, and this is a final pretrial, correct?
That's correct, Your Honor.
Has there been an offer?
Yes, Your Honor. This case was over at the annex, and we've given the same offer numerous times over at the annex on the record. That plea would be to an added count of felonious assault. We would be dismissing count 2, the assault strangulation, and count 3, the criminal sexual conduct in the second degree. There would also be an agreement, Your Honor, to HYTA deferral as well as a Cobb's to no upfront jail. The defense has rejected that offer numerous times at this point, so I believe we're ready to go to trial.
Was that Cobb's from me or from the other judge?
It was from Judge Kennedy.
Well, that doesn't matter. That's void. Let's not
Understood.
hear about what Kennedy does, but I would be agreeable to that,
But it's been rejected multiple times at
Okay.
this point.
well, okay. So is that full, fair, accurate, and complete?
It is, Your Honor. I've discussed the offer with Mr. Liddell multiple times, and he would like to go to trial.
Is that correct, sir?
That is correct, Your Honor.
And did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Did anyone promise you anything that caused you to make this decision?
Can you repeat? I'm sorry, it cut out.
Yes, did anyone promise you anything that caused you to make this decision?
No, Your Honor.
This decision has been made of your own free will
That's correct, Your Honor.
after you've discussed all the issues you wish with your attorney,
Yes, Your Honor.
and you've been satisfied with the representation of counsel?
Yes, Your Honor.
And have you taken any medication, used any marijuana, alcohol, anything at all yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Court is satisfied. We'll move this on to the trial docket. We have a trial date.
Yes, Your Honor. Looking at defense's docket, I believe the next date that would be available for all parties is November 6th.
All right, so, sir, will you still be in school November 6th?
No, Your Honor. I'll be graduated in May.
All right, and sir, you understand that with the plea agreement, you would be earning a non-public record, but if the jury finds you guilty of any of these, you could be a registered sex offender, you could end up in prison. You would not have the option for a non-public record because my hands would be tied, even if I wanted to do that. My hands would be tied. Do you understand the risk that you're taking?
Yes, I understand, Your Honor.
All right, this is moved on to the November 6th trial docket. I trust that meets with your schedule, counsel.
Yes, it does, Your Honor.
All right, thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Harry. I'll be in touch. Thank you.
Where did you Travis Mercer next?
This is docket 26, 598 FH.
Your Honor,
Yeah.
he's got to come out from.
Oh.
Sorry, thank you.
Counsel, you attended the meeting this morning?
I did, Your Honor. Thank you.
I figured, just wanted to ask. Thank you. This is docket 26, 598 FH, 25, 4861 FH, and 24, 836 FH. People of the state of Michigan versus Travis Lee, Mercer. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Jacob Sarge, the fourth assistant public defender here on behalf of Mr. Mercer. Mr. Mercer's president of the podium. He's standing by.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Taking any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
no,
Any sign of fever, COVID, or other illness?
no.
And I understand you've had multiple opportunities to talk to your attorney, including today.
Yes,
And there's a final pretrial. And two of the files, one is just a pretrial, but I suspect there was a global offer. Is that correct?
Not yet, Your Honor. There's a new case that just happened March 3rd that was waived yesterday, and then there's an older case still in district court to come up, so that'll be a total of 5 cases. What Mr. Sartz and I have been discussing is a possibility of, well, Mr. Sartz, I believe, is going to refer the defendant for a specialty court, and I have no objection. We wanted to address his bond on the record and have it revoked back
Didn't I already revoke it? Oh, you want to change the revocation
to
date?
March 3rd, so he gets credit from the time he's been in custody for that new charge.
All right, bond is remains revoked, but it will relate back to March 3rd,
I don't know.
2026.
Yes.
Okay.
I'm not sure that the court had. I know that the pretrial services sent a bond violation form on Monday, I think it was. So I don't know if Your Honor had a chance yet to review that. So we just want to make sure we had that on the record.
I don't remember if I signed multiple, all my signings up to date, so I suspect it's signed, it will be your inbox.
So we're on the record on all 3 of these files, revoking its bond back to March 3rd. I think that covers it. And then we will keep the court informed as to the progress of what the other steps we're taking.
So are we looking at a sobriety court situation, drug court?
Drug court, yeah. Yeah, they have a bit of wait list right now, but we'll get started on the application paperwork for them. We'll try to get them screened. And then I anticipate that process is going to take a couple months, but we already have one case that's on its way up right now as we speak. We have a second case that's set for a preliminary examination next week. So we need probably a couple months to get those 2 other files situated up here anyway.
What are they doing these days in district court? Do they give you a pretrial date?
We have a probable cause conference and a preliminary examination date. Mr. Mercer waived his preliminary examination on charges out of the 55th yesterday. Mr. Berman and I have another case that's at the district court stage. It's scheduled for next week. And
So assuming they bind it over, are they giving you a pretrial date on my docket?
no,
They're not.
no, on a
Okay.
circuit court arraignment date, Your Honor, it's usually
Or the
set for.
circuit court arraignment date, so can we, and I assume that's gonna be waived,
The circuit court arraignment is waived automatically, yes.
so can we use that date as a pretrial for all, or a status conference or something for, is that enough time for?
I mean, that, I'll defer to Mr. Sartz. I don't believe it is.
Well, can I give you, you know me, I do not like to adjourn without a date,
But
so can
for
we,
a status conference or pretrial or update of some kind, and I'll defer to Mr. Sartz on the link.
so like in May?
Yeah, that should be plenty of time, Your Honor.
Okay. Then if he is accepted, just set it in front of me or give me the paperwork to sign, and we'll just move all the files over. So we won't use the docket time, is that all right?
Sounds good, Your Honor. Thank you.
So how about,
May 13th, I'm being told is a good date, Your Honor.
May 13th, okay, May 13th at, let's just do May 13th at 9:30.
Thank you.
And I made a note, it should be on all 5 cases, it'll be a status. I'm gonna just put drug court. So I know why we're meeting.
Thank you, Your Honor.
Please, if the paperwork's there, I'll sign it and transfer them, and we'll save the time on my record, all right? Getting what you need over in the jail?
yes, ma'am.
All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
I never received that order in 3 trial. I can praise, but what is it based on?
Well, files.
Just hold until I get it.
It won't matter.
I mean, I can change the spot now, but
And all of those will be no bond.
as of March 6th. That was
He's not.
No, March 3rd. The road has March 3rd. That's all it allows.
Well,
okay.
The road bond, and then it doesn't matter, the rest won't matter, which is what we're doing.
and Deontay Chapman next.
March 3rd.
I'll look in a second. Right there.
You want to go quick first? Yeah. No. We're doing this first.
Yeah, okay, so I'm doing that.
I'm just letting her know. Deontay Chapman, yes.
Looking again.
Next case.
Deontay Chapman, Your Honor.
Oh, I got it. This is docket 24693 FC, People of the State of Michigan versus Deontay Chapman. Where is,
I apologize, Your Honor. I thought the defense attorney was in here. I guess he is not.
who is it?
It is Jacob Sarts. Yeah, so let's do Legions next, Your Honor. I apologize. That is at 9:30.
All right, this is docket 25369 FH, 23967 FH, 23969 FH, 256131 FH, People of the State of Michigan versus James Clare, the Legans, Senior. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Michael Anderson on behalf of Mr. Legans as to case number 23-967, as well as 23-969.
And Attorney Luke Goodrich to represent him on case 25-6131 FH.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Have you had enough time to speak to your attorneys?
Yes, ma'am.
And have you taken any medication yesterday or today?
Just my, for,
Just so you've taken something?
yeah,
Is it anything that would interfere in your
No.
ability to understand your attorney or the court?
no.
Is there medication you're supposed to be on that you're not on?
Check, what's that?
Is there medication you're supposed to be on that you're not on?
No,
Any sign of fever, COVID, or other illness?
no.
Thank you. And this is a bond motion?
It's a, if I may, Your Honor,
You may.
it's a bond violation hearing, Your Honor, on April 2nd. Is the court in possession of the new plea agreement that we've reached?
No,
Your Honor, may I approach?
please.
Your Honor, it's the third page of the new plea agreement. I added the old plea agreement, and that was entered April 2nd of 2025, where the defendant entered a plea on an amended information on file 23967 FH to count 3 as a have 4 under a 1-year delay pursuant to MCL 771.1. And if he remained bond compliant and had no new charges, he would be sentenced on count 3 as stated as a have 4 with no upfront jail at the time of sentence. Roughly on April 8th, so about a month and 6 days later, he was arrested for new charges, which is the file that Mr. Goodrich is here on, that being the 256131 FH. Pursuant to that original plea agreement, those other files that you mentioned were already dismissed. My plea agreement on April 2nd indicated that if he didn't do the 1-year delay of sentence, that the original count 1 on 23967 FH, that being possession with intent to deliver cocaine, would enter as a have 4 with no sentence agreement. What we've worked out at this point, and the reason why there's a new plea form, Your Honor, is that we've agreed that no sentence agreement part of the original count would be changed to a 24-month fixed Michigan Department of Corrections sentence, and that the new file that Mr. Goodrich is here on would be dismissed. So what I anticipate happening today, Your Honor, is that the defendant would plead guilty to the bond violation. That original count 1 as a have 4 would enter. We'd need a PSIR, just like a regular sentencing, to come back for sentencing. So what I would hope for to do today is have him plead guilty to the bond violation, get it on the record that we have this new amended agreement as far as the sentence, and then have it set for sentencing.
Okay.
There's no need for factual basis. It's all been done. I think you just need to get the bond violation and enter the original count. If that makes sense.
It does, but I'm looking for, so I have a bench warrant that was dated May 12th. Is that one, the one we're dealing with?
Probably.
File is pretty empty. I'm looking at, I don't know that my files are all up to date.
Yeah, I believe that's probably correct, because the date of offense for the new file that Mr. Goodrich is here on was May 8th of 2025. So the fact that it was sent to you on May 12th makes sense.
And Your Honor, we did have a bond violation arraignment previously. I believe that was in October.
Okay, so it looks like, and we did make some amendments at that time, so let me see. So what I have is that defendant should be held in contempt because of new criminal offenses. Defendant was in possession of brass knuckles, a dangerous weapon, and then we added and ammunition. And then defendant was in possession of illegal narcotics, specifically meth and cocaine. Are those the violations?
Yes, Your Honor.
So is he going to plead to these, or it sounds like they're already encompassed in a resolution, so I can dismiss this and go with the resolution, or how would you like to proceed? Because I think it was based on him not having any offenses, so really the violation would be that he has new offenses that voids the agreement. We can leave it at that.
However the court wishes to do it, like I said, I'm not concerned about him making statements against its interest in the new file, because once this goes through, it's being dismissed anyway. Obviously, things can go sideways and all that, but I wouldn't anticipate coming to court if something went sideways and using his statements against them anyway. So, however the court wishes to proceed, it's fine with me, and I defer to the defense. Thank you.
Can we just set all this aside and take dismiss or release all old agreements and stick with the new one for the reasons stated on the record?
Yes, sir.
Because that way, I don't want him to make statements against his interest. It sounds like some of this is going to be negated anyways by the plea agreement, and don't want to waste time. I'd like to cut to the chase.
I understand, Your Honor. I have no problem with that.
Mr. Goodrich?
Yes, Your Honor, we would agree with that. And just under I think perhaps the court could just ask him if he's accepting that he failed to live up to the terms of the old agreement or something.
So, sir, you would agree that you didn't live up to the original agreement, right? To stay clean for a year with no violations or new charges, right? Is that correct? Yes?
Correct.
Okay, so I'm going to, because there's a new agreement, okay, I'm just going to discharge or set aside the violation of the bench warrant, and we're going to proceed with the new agreement. Does that make sense to you, or do you want to talk to your attorneys about what's happening?
Makes sense.
Okay, it really just cuts to the chase and we're gonna get to the bottom line quicker. Is that okay with you?
It's all fine.
Now, do you need more time to talk with your attorneys or have you had enough time?
You're going through it already.
All right, thank you. And the agreement that was placed on the record by the prosecutor, is that full, fair, accurate, and complete?
Yes, it is, Your Honor.
It is.
Sir, do you understand?
Yes, I do.
All right, and then are you, let me see, waiving reading of, let's see if I even have this file, just a minute. Yeah. So you're waiving reading of 26.613 FH, 25.39 369 FH, 23.969 FH, and counts 2 and 3 on 23.967 FH. Is that correct?
Yes, Your Honor.
And so what will be read then is count 1 along with habitual, is that correct? The habitual fourth?
May we approach?
Yes. Oh, is that what it's not all agreed? Okay. I'll just have it down. So I just get this side. Okay.
Yeah.
All right, so sir, just as a reminder, you pled guilty to count 1, controlled substance delivery manufacture of a controlled substance known as cocaine, less than 50 grams.
Put guilty to a count 3 pursuant to the plea agreement. Count 1 was
So
just.
which one was it? But, oh, he pled to.
There we go.
I guess so. That's Sarah, so which, I've got the habitual fourth here, I just want to remind you what he pled to, this has been some time ago.
May I approach?
You may, because I don't think I have it. Okay.
Your Honor, I believe it was the third page of the
Possession?
document I gave you.
Yeah.
4 years.
Possession.
Okay.
And that's correct, Your Honor. And
Yeah,
these,
so the one is entry, correct?
Now it is, yes.
Yes, that's why I just want to read it to him, so he's got to
Okay.
count 1, but with habitual,
Yes,
so it would be up to life,
yes.
okay, okay.
So it will be a 10-year, but the habituals can come with it.
I just want to get this right, so.
As a max.
Okay, so it's not count 1, it would be count 3 under the, if we go under pay grades.
That you already pled to
That
last
he already
April.
pled to.
Now count 1 is.
So that.
The number of the
Yeah.
minimum.
Okay. So it is this what I was reading. Okay, so sir, do you understand, I just want to get this, there's a lot of agreements here and a lot of files. And so I want to make just a clear record so you understand. You've already pled and the agreement's been violated, we talked about that. So now what we'll enter is count 1, controlled substance delivery manufacture of a controlled substance known as cocaine less than 50 grams, which is a felony punishable by 20 years and or $25,000, and with habitual 4th offense notice, that is now punishable. There's the enhancement, so it's punishable by up to life. Under the plea agreement now, you will be serving a fixed 24 months in prison. Do you understand that? And then I step up like this. Is that correct now?
Yes, Your Honor. Minimum is 24 months, the max be set by court. Thank you.
Yes. Do you understand all that?
Yes, it is.
Have I stated it correctly?
Yes, Your Honor.
yes, Judge.
Okay, so, sir, bond is revoked and you will receive credit for your jail time, okay? And what I have to order now is a pre-sentence investigation report that will be completed by probation. And so they're going to come and see you and we'll all talk about it at the time of sentencing, okay? All right, anything else?
I don't believe so, Your Honor.
So the sentencing date, Your Honor?
Oh, yeah.
Oh,
We have a
goodness.
sentencing date?
May 20th at 10 a.m.
Does that meet with everybody's schedule?
Yes, Your Honor, thank you.
Yes, sir.
All right, thank you. Thanks for all of you.
Sorry.
All right. You want one?
No.
So. Isn't it?
I know.
No. James. May 20th at 10 a.m.
I already turned off the.
Okay. All right. Next.
Your Honor, the next ones that we have would be in custody. I'm just waiting for the officers to come back out so we can bring them out.
Is there any out of custody we can take while we wait?
Unfortunately, oh, yes, there is, Your Honor. We can move forward on Richard Norman.
All right, this is docket 25. 6720 FH, 24797 FH, and 24763 FH. People of the state of Michigan versus Richard Erin Norman. Counsel, your appearances for the record.
Good morning, Your Honor. Assistant Prosecutor Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, sworn on behalf of Mr. Norman, who is also present, standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken your medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any alcohol or marijuana you take?
No.
Have you had enough time to speak with your attorney?
Yes.
Any sign of fever, COVID, or other illness?
No.
And what is this is the final pretrial, what is the final offer?
Your Honor, the offer has been the same since the most recent case Mr. Norman's came up. That being for the defendant to plead guilty and file 24-797 FH to count 2, assault by strangulation, count 3, domestic violence, and an added count 4, domestic violence as habitual third offender with a sentencing agreement to a fixed 60 months. Now, that was already a very significant drop given the fact that he has very high guideline ranges in all of his cases and mandatory minimum 25-year imprisonment on with them. And they're discretionary consecutive with each other.
And they're what consecutive?
Discretionary consecutive with each other. To this day, I have never received a counteroffer.
I don't care, this is the final.
Oh, I know.
What this is the drop dead date, so,
But
sir.
when he is convicted, I want to make sure that's clear for the appellate record.
Okay, so I have notes and I think that he was in a straddle cell with your plea agreement. However, with the if he goes to trial, it would be, I have something like 43 to 172 or 50 to 200. I don't know what my notes. Can you tell me? Let's
Mine
talk
were 50 to 200,
52.
200, 50 to 200.
Okay. And
But
that's
again, he's got min 25.
with you what?
He has mandatory minimum 25 in play.
Okay, mandatory 25, but also you mentioned the cells, so I think we need to mention, so under the agreement now, what, with the fixed 60, if there was no fixed, what would it, is he still in straddle cell? I think we had talked about it, because I have some numbers here.
My apologies, hold on.
Does that make sense? Because I think we're obligated to let them know the difference.
Yep. I believe he is at the 38 to 114 plea offer.
And with the plea offer, there's no mandatory 25, correct?
Correct, Your Honor.
Full, fair, accurate, and complete, or would you like to add or clarify anything?
Thank you very much, Your Honor. The representations offered by counsel are, to the best of my knowledge, accurate and complete. We have not made a counter offer. My client is insisting on going forward with trial. Thank you.
All right, sir, you've heard the various options, going to trial and taking the plea, and you wish to go to trial?
Yes.
All right. Did anyone force, threaten, or coerce you to make that decision?
No.
Did anyone promise you anything that caused you to make that decision?
No.
And you've been satisfied with the representation of your attorney?
Yes, I have.
And you understand the huge difference between the plea offer and going to trial, what can happen?
Yes.
Okay, and it's your decision that you freely made that you want to have your right to a trial, is that correct?
That's right.
All right, do we have a trial date?
We do. I believe that we are on April 10th. This is not one of the first steps, but we are on that day and we've seen how things can move.
Okay, and which file is it?
Your Honor, I believe that there was a stipulation to joiner.
On all of the files?
Yes.
I don't recall that, Your Honor. I don't recall that.
Give me one moment.
Sure.
Yep. Stipulation and joiner was done. Oh, the on-base photo is a little bit blurry.
I remember that now because all three files have the same victim.
Correct, Your Honor.
Okay. So
My memory's been refreshed. Thank you.
mine was too, the minute I looked at
I
the,
just,
well, we all have so many cases, so. Sir, I understand you're gonna be going to trial on all three files.
Yes.
Okay. Bond and bond conditions will continue. You'll be ready for trial April 10th.
thank you, Your Honor. Yes.
Thank you. That's all for the record.
Thank you, Your Honor. I'm happy to back and forth.
I don't have formal, so. I just.
It's gonna be Nicholas Fuller.
It's at 9.
Sorry, who's next? Fuller, Nicholas Fuller.
I still gotta find it. That's you.
Yeah.
Thank you. This is docket 25-3398 FH and 25-724 FH, People of the State of Michigan versus Nicholas Allen Fuller. Counsel, your appearances for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Fuller, who stands present to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. This is a final pretrial. Sir, have you taken any medication yesterday or today?
Nope. No, Your Honor.
Marijuana, alcohol, anything?
Nothing.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you've had enough time to speak with your attorney?
Yes, Your Honor.
All right, and this is a final pretrial. I have to do these so that we have trial dates that are usable, because if you were to plead on the day of your trial, then you would be depriving someone else of a trial date. So I have to have a cutoff. That's why I hold these, so we can all know what we're doing. So what it was the offer, if there was one? Counsel, do you have the offer?
I do, Your Honor. So the offer covered both cases. The offer has been the same from the initial pretrial conference. That is for the defendant to plead guilty to counts 2, 9, and 10, and file 25-724FH, those being strangulation, GBH, and 2 misdemeanor domestic violences. And then plead guilty to counts 1 and 2, and file 25-3398FH, that being fleeing and eluding 3rd degree, and police officer assault resistive drug as habitual third offender with a fixed minimum of 48 months concurrent. As charged, his estimated guidelines are between 50 to 200 months with another discretionary 50 to 200 with a discretionary consecutive of 19 to 76 and a maximum of life in each file. Once again, there's never been a counteroffer at any point in these. So he doesn't want to take it, that's fine. We'll leave this set for trial. We have a trial date of the 10th.
I'm sorry, what? 10th?
10th of April. And there are discretionary consecutives at play here, given the fact that he was on bond at the time of the second incident. And that's also where they caught him with the victim while on bond.
So I want to understand the one that would go to trial would be the, let me see, the 724FH?
Correct.
Okay,
That's the older file.
yes. Full, fair, accurate, and complete?
It is my understanding of the offer, Your Honor, I have conveyed and discussed that with Mr. Fuller. And that is my understanding as well, is that should there be a trial, the older file would be the priority. My understanding is we are on the docket currently for April 10th. My understanding from having discussions with the docket prosecutor is that we are very low on the priority list for that day. Should that change, we would be prepared to go to trial to that day, although as it's looking now, that's probably not likely.
Well, we'll get you a secondary backup date. Sir, would you, is the plea offer, is that your understanding? Is it full, fair, accurate, and complete?
Yes, Your Honor.
And is it your intention to go to trial or to take the plea offer?
To trial, Your Honor.
And did anyone force, threaten, or coerce you to make that
No.
decision?
No, Your Honor.
Did anyone promise you anything that caused you to make that decision?
Not at all, Your Honor.
You made that decision of your own free will?
Yep.
After considering all your options,
Yes, I have, Your Honor.
talking with counsel,
Yes.
and you've been satisfied with the representation of counsel?
Yes, I have, Your Honor.
And you stated you're ready to go to trial, is that in fact true?
That is true, Your Honor.
So I'm gonna keep the April 10th date, but we're gonna give you a backup date. Counsel, can you please give me a backup date?
Yeah, no, I tried that. That works for me.
October 23rd.
Is that October date? October 23rd, I've got a I hear you talking about October 23rd. The 30th might be possible, but the 23rd won't because
Correct.
the case is gonna go.
That is the realization we were just having back here.
Yes, we're gonna have a 2-week homicide case on the 16th.
Correct, Gary. October 30th, Your Honor.
Okay, October 30th. So your backup date's October 30th, bond and bond conditions will continue, and there remains a no contact order. No contact means no contact. If I end up hearing that you are having contact, I will revoke bond and don't bother asking for it again. I don't care what you got going on in your life, you violate bond. I don't care. I got 1 file, now I got 2 files, and there's an allegation that you were found with the victim. If that happens again, the way to keep you apart is by giving your share of Uber ride and hotel stay in Mason until trial. And trial hopefully will be in April, but it could be October, it could be January. So it depends on how you want to live your life, sir.
Yes, I understand, Your Honor.
No contact means no contact. They don't exist in your world. No Hallmark cards, no Halloween gifts, no Valentine's, no phone calls, emails, contact through third parties, no messages by carrier pigeon, smoke signal, or otherwise. You get creative. I'm not so creative. It's just jail. Got it?
Yes, Your Honor.
Have I been clear?
Crystal, Your Honor.
Yes, you have, Your Honor.
Thank you. That's all for the record.
Thank you.
Thank you, Judge.
And then Deontay Chapman next.
Bart's being very nice and getting through mine.
All right, this is docket. Are you ready? 24-693 FC, People of the State of Michigan versus Deontay Chapman, counsel. Your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Jacob Sarth, the fourth Assistant Public Defender here on behalf of Mr. Chapman. Mr. Chapman is present at the podium. He's standing by.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Do you put your hand down? Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Hands out of the pockets for safety, please. And have you had enough time to talk with your attorney?
Yes, ma'am.
And this is a final pretrial. And that's so we can keep everybody's case moving, because I don't allow pleas on the date of trial, because then you would have deprived someone else who wants to get to trial. So I have to have a cutoff date. That's why I have this. Okay, so there has to be a time where you decide finally what you want to plea, to go to trial. I don't know. So let's see. Has there been an offer? It looks like we've been here before.
We have, Your Honor. There has been an offer. The offer is for the defendant to plead guilty to count 2, home invasion of the first degree, count 4, assault by strangulation, count 6, interfering with a crime report, and count 7, domestic violence, with a sentencing agreement to a fixed minimum of 60 months. As charged, his guideline range is 108 to 180 months, with a discretionary consecutive 78 to 130 months, and a maximum of life in prison. It's actually discretionary consecutive there. As with the plea offer, the guideline range drops to 78 to 130, and our offer is for 60. It's my understanding he does not wish to accept that offer. It's my understanding he does not have any counter offer for anything he'd be willing to accept. So we're leaving this set for trial. I believe this is the backup trial on April 10th. I am fully anticipating and planning for it going on the 10th.
Your Honor, I would respectfully disagree in terms of no counter offer. Our counter offers, though, have been more so in the county cap kind of range, which the prosecutors made it very clear to me he's not interested in extending at this time.
My apologies. That was misinformation.
Thank you.
Okay.
But that is correct, Your Honor. Mr. Chapman is not interested in accepting the prosecutor's offer at this time. We will be prepared and ready to proceed on April 10th. It's my understanding, though, that we currently have 3 cases that are ahead of us, 3 people who are in custody. This is a 24 file, 693 FC. So it's a capital trial, from capital charge from 24, Your Honor.
All right, and I have here, now this might have been this has been, I don't know why we're having a final pretrial. It looks like we've had multiple final pretrials. Why are we doing this again?
I think more as a status conference.
I don't care. Trial date's trial date. Same result. Let's stop wasting my time.
Agreed.
It was a final. I have all these notes, and I have the April 10th date. And I said, don't move, but if we have to move, and I've got June 13th as a backup, I don't know. Is that
Correct.
That's fine, Your Honor.
Is that what we've got?
Yep. June 13th, understand, Mr. Chapman? Okay.
Okay, fine. Well, sir, you've heard the plea agreement,
Yes, ma'am.
and it's your decision to not accept this. And you want to go to trial.
Yes, ma'am.
And no, did anyone force, threaten, or coerce you?
No, ma'am.
Anyone promise you anything?
No, ma'am.
And you made this decision of your own free will,
Yes, ma'am.
and you remain satisfied with your attorney?
Yes, ma'am.
And you'll continue to work with your attorney toward the trial dates. It will either be April 10th. You must, I suspect, your first one up. This is an old case.
The first out of custody.
Yeah, and if not, looks like it'll be June 13th. So you'll be ready with your attorney?
Yes, ma'am.
Bond to bond conditions will continue, and again, no contact means no contact. It doesn't look like there've been violations, and we've had a few motions, so it looks like we are ready. You don't anticipate any additional motions, is that correct?
I've not seen the exhibit list yet from the prosecutor, but I anticipate no at this point, Your Honor, but I will reserve that in case something pops at the last minute. From what I understand, the people sent in a very short witness list to me, only 2 listed witnesses. So I don't anticipate a lot of additional motion practice at this point. Your Honor.
It's gonna be a pretty straightforward trial with victim, responding officer, the injury photos. And if need be, the body camera.
Okay,
Okay, thank you, Your Honor.
thank you. That's all for the record.
Thank you, Your Honor.
We need Rochelle Jones next. It's at 10:30.
This is docket 254036 FH, People of the State of Michigan versus Rochelle Jones. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good morning, Brian Jackson, on behalf of Ms. Jones, who is present in the courtroom for sentencing.
Thank you, ma'am. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Use any marijuana, alcohol, or other substances?
No, ma'am.
You had enough time to speak with your attorney?
Yes, ma'am.
And you've also read, reviewed the pre-sentence investigation report?
Yes, ma'am.
All right, thank you. On behalf of the people, any corrections, additions, deletions?
The only thing, Your Honor, is there are multiple places in this report where it states a Killebrew agreement stipulates no sentencing agreement. There was no Killebrew agreement in this case, so
I'm just going to strike no and just put no sentencing agreement.
I would appreciate that, Your Honor.
Counsel, do you agree with that?
Yeah, I got it.
Yes, Your Honor.
Thank you, and so it's on the,
It's on the cover sheet, Your Honor,
and then evaluation plan.
evaluation plan, and I believe it's in one other spot. Give me a moment. Never mind, those are the 2 spots.
I've made the same correction. All right. Mr. Jackson, any corrections, additions, deletions?
Your Honor, Ms. Jones says that she did 4 days in jail. I don't know if there was like a case that got dismissed and reissued really quick, but it reads 2, she says 4. I don't think it's a big difference, but that's what.
Any objection to putting?
No objection, Your Honor.
Okay, I am putting 4 days on the cover page, basic information sheet. And then, so what would those, Mr. Jackson, any idea what the dates would be? So under recommendation, I need to put the dates.
Third through the 5th.
Let me just see, so July 6th, that was a Sunday. It says, so it has you as Sunday and Monday. Were you arrested maybe Friday?
No, it was on a Thursday.
So Thursday would be.
Yeah, they put the warrant out
And
Thursday at 2:30 that I didn't know. I was with one of my friends. He got pulled over, and that's
Okay.
how I found out.
Okay, so were you released then on Monday?
Yeah,
So that would be 5 days. So I'm going to change it to July 3rd. Through the 7th, and then that's 5 days. So let me make that change. On behalf of the people, any objection?
No, Your Honor.
Okay, making on basic information sheet, the recommendations, the cover page. And also item 21, recommendations. And then under the recommendation narrative. Okay, I think I've got all the places. Any other corrections?
No, ma'am.
How about as to the guidelines?
There are no guidelines.
Oh,
Correct, Your Honor, this is missing in the
yeah,
plate.
okay, got it. Should have looked at that first. So ma'am, you pled guilty to aggravated assault aggravated, which is a 1-year misdemeanor. Do you recall that?
Yes, ma'am.
All right. And do we have a victim here?
I don't believe so, Your Honor, but let me double check. Is Miss Riley here? No, Your Honor, there is no victim.
All right. On behalf of the people?
I guess, Your Honor, I would just ask that you follow the recommendation in this case of 6 months probation with a substance abuse assessment as well as anger management. I believe both of those are appropriate given the situation in this case, and I would ask that you follow that recommendation. Thank you.
Counsel?
Thank you, Your Honor. Just a little background, and I'll try to be short because ultimately we are asking that you follow the recommendation. But this incident, first, Ms. Jones has a very, very minimal criminal history for a lady that is 40 years old. She was celebrating her birthday on the weekend, and an uninvited guest came over, being Miss Riley. Miss Riley was intoxicated and caused a little bit of a disturbance, and Miss Jones ultimately told her to leave. Miss Riley swung at her and ultimately hit her and cut her face, causing it to bleed. Once Miss Jones, and then Miss Riley left. Once Miss Jones realized that, Miss Jones came outside and then fought her, basically.
And then what?
Went outside and fought her, causing injuries to Miss Jones. Miss Jones drove away and was subsequently stopped for and investigated for operating while intoxicated. And then that's how the officer found out, and then ultimately investigated the assault. Miss Jones is remorseful for that day, and that was just a very bad way to celebrate your 40th birthday. Some she'll always remember. But moreover, Your Honor, Miss Jones has maintained her employment at McDonald's full time. We had a letter that just reads that she's a good worker and shows up on time and has good spirits. Also, somewhat related to this matter is that since that day, her son, who was listed as a co-defendant because he jumped in a little bit also, he passed away in a drowning on September 13th of last year. And he was 16 years old. That's obviously traumatic and sad for everybody. Miss Jones is asking for her probation term to be followed. She was seeing a counselor. She did miss 2 days and is not seeing that counselor anymore. She went to sign up for anger management, and they were charging $120 for an online 1-day class. She decided to wait for that to see what happens in court. We don't think that alcohol or drug treatment and testing is necessary because this wasn't necessarily a matter of intoxication, but a matter of making a poor choice on how to react when she was initially assaulted. And again, we went through in the plea about how self-defense only lasts so long until you're in a safe place, which what should have happened, it should have stopped, but it didn't stop at that point. So we would ask that you set an appropriate sentence considering all of those things. Thank you.
Ma'am, what would you like me to know?
I apologize about the whole situation that happened. I learned my lesson. And I'm never gonna put myself in this predicament ever again. I'm just hate that she got injured. And I learned my lesson.
Is there any restitution that's being sought?
No, Your Honor.
So ma'am, I've read, I mean, your life story is very sad. And I'm sorry that you had to go through all that as a child and now into adulthood and losing a son. I can't imagine everything you've gone through. I think most people would have given up. So things that happen to us, they are teachable moments. And I do believe you when you say you learned your lesson. But I also believe that there are countless people in your life who failed you. I also see that you're carrying a lot of grief and trauma. And that you're just sort of walking through life because you don't know what else to do. But go forward. Does any of that make sense to you?
Yes, ma'am.
So I'm gonna put you on probation, not because I think you need to go through everything, I'm gonna cut a lot of this out. But because probation is not a punishment, it's to help you. You need grief counseling and you need trauma counseling. I would agree with your attorney, you don't need substance abuse counseling. If we do find the random testing that you are using, I'll add that in. But I think you've got so much grief and trauma swirling around in you that you gotta get a handle on it. And I don't know how you get over the loss of a child, but I do know that it was an honor to be his mother and to know him. And so you need to understand that he's still with you, but in a different form. And you can talk to him. And you'll see him again someday, but God has a plan. Right now, you're not with him, but he's not gone forever. We're coming to that feeling of understanding that this is quite a journey, and I don't want you to walk that journey alone. Okay? Do you have anybody that you can rely on? Because I don't see anybody here that you can rely on.
No, ma'am, it's just me.
Yeah. Well, you have too heavy of a burden to carry by yourself. So we're gonna get you some help. Okay? I don't want you to give up. I don't want you to turn to drugs or alcohol. I don't want you to shift your anger and pain onto other people or yourself. I see too much of that. But I do want you to know this report, I mean, I don't know if I would be as strong as you. From the time you were a little kid, you only had yourself. So I want you to know I'm putting you on this probation to help you and to maybe not just start the healing, so you can have a tribe around you of people who support you, because everybody needs that. I need you to find your tribe. I don't know if that's gonna be with your therapist or some activity that's recommended or church, or I don't know. People find their tribe in different places. And you cannot walk this journey alone. It is very clear to me. So I'm gonna put you on probation for 12 months. If you are doing well after 6 months, you certainly can be released. Okay? You shall not use, possess, consume, purchase alcohol, illegal drugs, or have drug paraphernalia. If you have a need for any of those things, you'll present a prescription from a licensed medical physician. You'll be randomly tested. I don't think we need to set anything like 3 times a week or whatever, but if you are tested and you're positive, then you'll go through a substance abuse assessment, and then we'll look at whatever that says, treatment. You will participate in grief counseling and trauma counseling. You know what your issues are. They can be the same therapist, I just don't know, because they all have different treatment. And I don't know if you need EMDR treatment, or, and there's so many different things now that call for special treatment and training. And so I leave that up to you and probation and your therapist to figure out. You'll have to attend your therapy on time every time. I want to do it as outpatient. If things get really bad, I can put you inpatient, but I don't think we need to do that either. You'll need to sign all necessary releases so we can verify that you're doing what you need to do. All that means is that we want to know not what you're talking about, that is between you and your therapist. It is a release so that we can verify that you're attending your appointments, that you're following the recommendations and showing up on time and participating. Does that make sense to you?
Yes, ma'am.
Okay. I believe that now all of these kinds of treatment counseling are cognitive based. If they're not, she'll also do cognitive behavioral, but I believe they all are now include cognitive behavioral that everyone would benefit from to learn to make better choices. You will not have verbal, written, electronic, or physical contact with Katera Riley, Katerra, either directly or through another person, and you will not be within 1,000 feet of their residence, school, or place of employment. You will obey all court orders and recommendations of all treatment providers, including probation. You'll possess a valid state of Michigan driver's license or identification card. Keep that on you at all times. You will not engage in any assault, abusive, threatening, or intimidating behavior, and you will not have any contact with anyone housed in the Michigan Department of Corrections or who is on probation or parole. Now, you may work with some people who are in probation or parole. You don't have to ask every single person, but if you find out that someone is in good standing and they're on probation or parole, just let the probation know, and I will allow that to continue. Does that make sense to you? Yes?
Yes, ma'am.
Yes.
Thank you, Your Honor. She has a son who is in
The Department of Corrections, I saw that. So as long as you're doing well, you can have contact with him, but not other inmates.
But not what?
But not other inmates. Does that make sense to you, ma'am?
Yes, ma'am.
Okay. Do you know when he's getting out?
2030.
Okay. You allow probation in your residence at any time for probation supervision without a warrant and submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer if there's reasonable cause to believe you have items that violate the conditions of your probation. You report any arrest or police contact, loss of employment, change of residence, or personal protection order placed on you within 24 hours. Weekends and holidays are accepted, so if something happens on Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You'll maintain your employment. If at any time you lose your employment, you will be part of a work seek program. I would like you to complete your GED. Is there any reason you can't?
No, ma'am.
All right, let's get you in your GED. What do you want to, I mean, you could be on this planet another 60 years. You want to stay working at McDonald's?
No.
Okay, what do you want to be? What do you want to do?
I really don't know.
Okay. Well, when I was in practice, I had a client who actually worked at McDonald's and worked her way up into management. She retired very, very well. So, and I think McDonald's even helps pay for things like education and whatever. They actually have some really good programs. I don't know if you're eligible for that or not, but it seems to me like you're really smart. You've had a lot of bad breaks. You could own a McDonald's. But let's get you finishing your GED and explore your options, man. And maybe you can, what's your position at McDonald's?
I'm a crew member.
Okay, so you can work your way up to manager or district supervisor, whatever those titles are, couldn't you? Is that something you want to do? You don't want to do that?
No.
All right, well, let's look at some other options and get on the road to greater success.
Get on the road to what?
Greater success.
Thank you.
I think you certainly are capable of that. I think you have got so much other turmoil that you're not looking down the road. But let's get looking down the road where you want to be, have a good retirement. You do have a right to enjoy your life, man. You are worthy of doing that. But that's a choice you have to make. Okay?
Yes, ma'am.
You will serve 365 days jail with credit for 5 days served. The balance is held. We don't have to use any of that unless you are doing well. You will pay crime victims assessment, the amount of $75 and a $50 state cost. I'm waiving probation oversight. And I am waiving any fines, costs, attorney fees, and finding you're indigent for that. And you'll not use any object as a weapon. You'll not own, use, possess any kind of weapon, gun, imitation of a weapon. And you'll not use marijuana unless you have a medical marijuana prescription, then you'll only use it as prescribed. Same with alcohol, you'll only use alcohol as prescribed. Sometimes that's part of a cough syrup or something, so. You just need to let us know what you're prescribed, do you understand?
Yes, ma'am.
You have 42 days to appeal and to request appellate counsel. Please stand for appellate rights. Do you have any questions? Is there anything I told you to do that you can't do?
Well, right now, I'm just trying to focus on trying to get myself back together. So right now, I'm like going to school. It's not like,
Well, you don't have to do it all at once.
you know,
Let's get you situated emotionally, and then we'll start you going to school, and if it becomes a roadblock, we'll see. I mean, maybe you can swap trade schools for that or something, but man, people can take away a lot of things from you, but they cannot take away your education. And if you don't want to stay locked in McDonald's, let's get you on the road to a GED, and you can go to Lansing Community College. They have a Reconnect program. You can go to college for free. Let's get you on your road to success in every way. But let's start with the emotional needs that you clearly have.
well, mentally, I need to get my head straight before I can do
That's
that.
why, exactly. So I'm not saying you have to do this all at once, okay? You talk with probation about that. If there's anything that is a problem, they can talk to your lawyer or me, and we'll work it out. But let's work on the grief and trauma therapy first, because I see it. I feel it. You do have to get your head on straight, but you can't do that alone, man. Not working very well for you. You've been alone for far too long, fighting this battle. So you need a trained trauma therapist and grief therapist. Like I said, they can be one, but you have got to have that as a priority. This is meant for your success. It's not a punishment. Jail is a punishment. Any questions?
No.
Do you acknowledge receiving your appellate rights?
Yes.
All right, good luck to you. Thank you.
Let me do Lorenzo Garza next.
They're trying to.
This is docket 25842 FH and 25845 FH. People of the state of Michigan versus Lorenzo, Freddy, Garza. Counsel, your appearance for the record.
Good morning, Your Honor. APA Brett Bucks on behalf of the people of the state of Michigan.
Good morning, Your Honor. Jacob Sarge, the fourth assistant public defender here on behalf of Mr. Garza. He's at the podium. He's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You put your hand down. Are you taking any medication yesterday or today?
No, Your Honor.
Any alcohol, marijuana?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with your attorney?
Yes, Your Honor.
And this is the final pretrial on both files?
That's correct, Your Honor.
And what is the offer?
The offer in this case, Your Honor, is to be pleading on both files. In 25-842 FH, the defendant be pleading to an added count 5 home invasion 3rd degree, and the remaining counts would be dismissed upon plea and sentencing. In file number 25-845 FH, the defendant be pleading to an added count of stalking, and the remaining 4 counts would be dismissed. In running those guidelines, Your Honor, on the first matter with the home invasion, the defendant, if going to trial, would face 72 to 150 months if to go to trial. In the plea, Your Honor, the guideline range is 14 to 29 months. In the other matter, Your Honor, it is a misdemeanor, so that it would be the 1 year maximum misdemeanor.
Full, fair, accurate, and complete?
Yes, Your Honor.
Is there, I'm sorry, let me just ask, is there anything, is any part of this, or is there a sentence recommendation in Killebrew or no?
There is not a Killebrew at this time, Your Honor.
Thank you, Your Honor. Yes, Mr. Garza has been previously informed of that offer, and Mr. Garza rejects that offer at this time. He requests that we leave this matter on for his scheduled jury trial. It's my understanding he's currently set for April 10th. Obviously, the odds are pretty low at this point that we're going to
They're
be.
pretty low.
Yeah.
Do we have a backup date?
I would say October 9th, Your Honor.
Okay, if we don't go April 10th, it'll be October 9th. Sir, you've heard the plea agreement?
Yes, Your Honor.
It's full, fair, accurate, and complete?
Yes, Your Honor.
And you've spoken with your attorney about it?
Yes, Your Honor.
And you're rejecting it?
Yes, Your Honor.
And did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Anyone promise you anything that caused you to make this decision?
No, Your Honor.
You've made this decision of your own free will?
Yes, Your Honor.
After you talked with counsel?
Yes, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
And you understand there is a vast difference between the plea agreement and what could happen if you were found guilty?
Yes, Your Honor.
And you wish to avail yourself of your right to trial both files?
Yes, Your Honor.
We're satisfied. I'll see you at trial.
Thank you, Your Honor.
Thank you, Your Honor.
Give me 1 minute, please.
Yes.
Who's talking in the back?
All right, I need everybody who's talking to go in the hall and talk. Thank you. Next matter.
Antoine, Nance, Your Honor.
Good morning.
No. 11 o'clock.
All right, this is docket 22-806 FH and 25-6168 FH, people of the state of Michigan versus Antoine Nance. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of people of the state of Michigan.
Good morning, Your Honor. Toby White, I'm here on behalf of Mr. Nance. He's with me at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
And you put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Used any alcohol or marijuana or other substance?
No, ma'am.
Is there any medication you're supposed to be on that you're not on?
Vicodin for my right knee.
Okay, but you're not taking it?
No,
Do you need to take it?
I probably should, but it happens like every so often with the
Okay,
weather, you know.
yeah, okay. So you're okay proceeding without taking that?
Yeah.
And do you need to sit down?
No, it's okay.
Okay. And any sign of fever, COVID, or other illness?
No, not that.
And you had no time to speak with your attorney?
Yeah, I had time.
Okay, you read the pre-sentence investigation report? This information?
Mhm.
Okay. All right, great. On behalf of the people, are there any corrections, additions, deletions?
There are, Your Honor. All throughout the basic information report, count number 7 is stated as controlled substance possession / narcotic / cocaine, 25 to 49 grams. That is not what he pled to, Your Honor. It is a controlled substance possession of narcotics less than 25 grams. So that needs to be changed on the basic information. That needs to be changed on the cover sheet, in multiple places.
Okay, let me go through. So I'm looking at the basic information sheet, and that's 3 of 3.
Correct, Your Honor. That's it.
made a change on the cover page.
And it would also be in the recommendation area on
Yeah.
the cover page as well.
Change.
It's also in the evaluation and plan, Your Honor.
That's in the first paragraph. And that would also be the
Criminal history on page 7, Your Honor.
yeah. Let me just see on the
6 of 7.
Is that still a controlled substance G?
Yes, that is still correct, Your Honor. It's just the title itself needs to be changed.
Okay, and then we need to go to does this affect, did they mess up the guidelines then?
No, the guidelines would still be correct as well, I still have an argument in regards to the guidelines, but this change itself does not change the guidelines.
Okay.
It is still a controlled substance G.
Okay, all right, so I have made all the changes, including on the sentencing sheet, the guideline sheet. All right.
And that would be the only changes I have to the body, Your Honor.
Counsel, do you have any on behalf of defendant?
On behalf of the defendant, we agree with those changes and I have no additional changes.
All right, and as to the guidelines?
I believe guidelines are scored correctly.
All right, we have the people, you said you have some?
Yes, Your Honor. OV 12 on all 3 counts is currently scored at 0. However, Your Honor, OV 12 is in regards to charges that were dismissed. There were 3 counts dismissed, so I believe that OV 12 should be scored at 10 points.
I've discussed this with the prosecutor and he and I agree.
All right, OV 12 is 10. Is that the only change on the OVs?
That is the only change in all 3 files, Your Honor. That does change the total OV to 25. It changes the OV level to level 3. And it changes the guideline range in the first 2 counts to 10 to 23. And it changes the final count to 2 to 17.
All right, let me make those changes on the basic information sheet. Okay, those changes are reflected now in this information sheet, and then are they mentioned in the recommendation narrative?
They are, Your Honor.
Okay, so we need to change the range. Now the range, 10 to 23 and 2 to 17. Okay. So I think everything, I think everything is consistent. Any other questions?
No, Your Honor.
All right, and on behalf of the people.
Yes, Your Honor. Reading through the recommendation states 24 months of probation with 170 days jail with 170 days served. Your Honor, the people are concerned with the defendant's drug use. It seems as if he states in the report that he's a regular cocaine user since 2018. It does state that he ended in 2024. However, in this case, Your Honor, he was found with 15 grams of cocaine, which leads to some issues that I have in regards to his use of cocaine. So I believe that either some kind of inpatient treatment and or TRICAP would be appropriate in this matter, given his history with these drugs. However, I would agree with the rest of the recommendation, Your Honor.
All right,
Thank you.
and sir, just as a reminder, you pled to count 3, weapons, firearms, possession by felon, punishable by 5 years, count 5, police officer fleeing 3rd degree under the motor vehicle code, punishable by 5 years, and count 7, controlled substance, possession of a controlled substance known as cocaine less than 25 grams, punishable by 4 years. You recall all of that?
Yes.
And counsel?
I agree with the recommendation. I'll be a little brief because I agree with it, and I know that we're in agreement with the prosecution that the recommendation is appropriate. And neither he, and he'll obviously address you in a minute, nor I disagree that continued outpatient treatment. I did show this to Mr. Buxton, and I showed off the record to you, his most recent stint where he completed a journey to recovery up at Bear River. And Bear River is well regarded. He has no problem following any kind of recommendation regarding this drug thing. It's plagued his life. It's hurt his life. It's hurt those around him. His mother's in the court. I spoke to her just very briefly. My auntie. I'm sorry, is your aunt? Yeah, I lost him. He lost his mother. I'm sorry, incorrect. But she has said that, you know, it looks like he's turning the corner. And in cases like this, let's help him turn the corner. That's what I think is appropriate. 143 days, I think, is enough of a sanction as far as incarceration goes. He can always, you know, he's got the sword of Damocles hanging over his head. He's got guidelines that would allow you to send him to DOC if he doesn't follow these recommendations and stay clean. But let us give him that chance. As I refer to as put the guardrails in place and he'll abide by them. And you know, he's not resisted to it at all.
Sir, what would you like me to know?
I'm done wasting my time with my life, the rest of my life, and messing up and just looking foolish. And I do have 3 kids of my own, so like they all look up to me.
How old are they?
Ranging from 18 down to 12 years old.
So do they live with you?
No, man, they stay with their mom currently.
What else would you like me to know?
If I get another chance, I will never mess up my life like this again, because it's already scary enough just throwing my life away, just sitting down the way I did. Going to jail just ain't for me.
So I have here your former significant other, and then I have your children. I have a son, 15, but then below it doesn't make sense. That's why I just want to clean this up. It says defendant reports you've never been married, you claim paternity of 3 children, ages 10, 16, and 18, but I have a son, 15. Is the son now 16?
Yes, yes.
Okay, and then I have a daughter, 11.
Yep.
Is she now 12? She was 10, now she's 10, 11, or is she 12? How old is she?
She is 12 now.
Okay, 12. And then looks like I'm missing the 18-year-old. Is that right?
Kyler, my oldest.
So how
he just recently, not too long ago, had a birthday.
Okay. And how do you spell his last name?
Kyler, Kye.
Kyler?
Ler.
Kyler?
Yeah.
Common spelling?
Yeah, I got it.
And is his last name Nance?
No, ma'am.
What's his last name?
Corliss.
Okay. Okay. And they're all in school, they're all students?
My oldest is not. He's got like a seizure issue, and he just turned me into a grandfather.
Okay. So he's working?
Yeah, he's currently working with his grandma,
Okay,
and the other two are in school.
okay. And what does Ashley do, the mom?
She works 2 jobs.
Okay, because it says she's a student.
Yep.
They just got a bunch of boxes wrong.
No.
So, all right, so she's employed. I'm just gonna put employed.
Yes, ma'am.
Okay. All right, so it also says that you've been unemployed since 2014. Why?
They told me not to work,
Who's they?
and the people that pay me my disability.
Okay, so you're on disability.
Yeah,
Oh, okay, so is it SSD or SSI?
SSI.
Okay, so I'm just
What's the
gonna put-
difference between those? Is one?
So one
word?
SSD is because you put in so much money into Social Security.
Okay,
So
SSI.
you must have been injured for quite a while.
Yeah, SSI.
Okay. So I'm changing the report to under the employment narrative, defendant is currently unemployed because he is on SSI. Okay, so I'm also, where it says on the cover page unemployed, that's not fair, I'm just gonna put SSI. Okay, so do you have physical and handicap? You don't have a handicap, you just have some, I don't wanna get into all your illnesses, I just want the report to read. This is physical health, no physical health issues are found.
More
You have
mental.
knee issue,
Mental health.
you have some mental health issues?
Well, I had classes. I had special classes growing up.
Okay.
And
Oh, you said, it does say cognitively disabled. So this is just a weird report. Okay, no mental health issues are found, but he is cognitively disabled under the next one.
sorry about that.
That's not your fault, that's the drafter's fault. So under mental health, I'm just scratching out no mental health. I'm just gonna put C below under the narrative. Okay, anything else you want me to know, sir?
I'm far from the man that I used to be, and I got a different outtake on life instead of just being bummed out and giving up because I lost my mom. I'm not gonna use that as an excuse. I'm gonna actually use it to further better myself.
So when did you lose your mom?
I want to say like 7 years ago, somewhere around there. It's been quite a while. It's hard for me to go back and think about things like that. My memory is not very good. That's one of my disabilities. I have a hard memory. If it's important, like going to do things like as I'm told, I'd have to write it down and take a look at it, you know, like a planner.
So who do you live with?
My auntie.
Okay, and that's going well?
Yes.
Okay.
Been staying out of trouble. Basically been at home and just really thinking about my life.
So tell me about Bear River. Did you complete it? That certificate you gave me, that's completion?
Yes.
Because you attended like 25 or 27 classes or something, I saw, right?
Yes, ma'am.
Okay, so did they give you any aftercare? You know what I mean by that? Did they tell you some things to do or?
Yeah, they advised counseling, basically counseling, and then they asked about AA classes.
Have you gone to any AA?
Not since I've been here. I've been really looking forward to what they're gonna say for court. I don't have any problem with following any guidelines. I just want another chance at life.
Well, that's all up to you, sir.
Yes, ma'am.
If your mother's standing next to you, she's telling you to live life to the fullest, isn't she?
Yeah.
I mean, she'd be disappointed being here in court, wouldn't she?
Yeah, truly.
So you don't honor your mother by using cocaine or other drugs or doing anything, chasing after police or using weapons or any of the things you've been doing.
Yeah, I learned the hard way.
How'd your mother die?
I'm sorry. I got locked up and I felt lesser of myself since I've messed up, and I take better initiative over life now.
So how did your mother pass? She must have been young.
Yeah. She abruptly died when I was sleeping. I woke up to her gone. She died off of drugs. Bad drugs. Looked like she didn't have a chance.
She's telling you to not take drugs and to live, right? Live for her and for you, without drugs, right?
Right.
Because if she had a choice, she'd want to be here with you and the family, right?
Yes, ma'am.
So get a handle on it,
I would.
for you and for your mother and for your family.
I would.
And, you know, police officers, they first and foremost are peacekeeping officers, and they're there to help you. So if it would have been possible to call 911, they would have shown up very quickly at your home to help your mom, or to help you, or help anyone. So if they're chasing someone like you, they can't help anybody. So they're your friend. I know that often they're not seen that way, but they ought to be respected. So no guns, no weapons, no disrespecting law enforcement. You just gotta change, sir.
I understand, and I will.
Okay, so I'm gonna put you on probation for the 24 months. If you do well, you can get off early. If not, I will extend it. I can also send you to prison. I take it you didn't like those 170 days in jail.
No.
Well, it doesn't get better in prison. But if I have to send you to more jail or prison to save your life, I will do it. I am the mother you do not want. So you honor the mother you had. You shall not use, possess, consume, purchase, or be in the presence of any alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. So I know you have some prescriptions, you'll just need to let probation know what those are.
Okay.
You will be, so how often have you been drug tested recently?
I haven't. Leading up to court, that was pretty much where it was standing. I just had to call and check in.
Okay, so when was the last time you were tested?
It's been quite a while.
Okay, so if I
The
gave you
last
a
time
drug
I
test
did
today, is it gonna be clean?
Yeah, it should. Yeah.
When not, yeah, it should be.
It will.
You need to say, yeah, it will be.
It will.
Yeah, okay. So, sir, I'm gonna order random drug tests, and if you are positive, you will have a secondary test taken so that we can make sure it's a positive and not a false positive, and then you will immediately be placed in TRICARE. I'm not gonna wait for probation hearing. I'm not gonna wait for you to get high again. I'm not gonna waste anybody's time. I will put you in residential long-term treatment. Unless you truly tell me it's false, but that's why I have that secondary test. You can talk to your attorney about that. I will order, I'm not gonna order TRICARE now, I could. But you've done Bear River.
Yes.
I think you're on the right road, but you wanna fall off, you're going right into residential treatment. Then if that does not, and including any aftercare, and if that does not work, then that X violation will be brought in front of me. And
Okay.
we'll talk about where we go, and I don't think you'll like it.
I understand.
You will attend AA, NA, or CA at a minimum of 3 times per week, and within 90 days, you will have a sponsor who has gotten clean and sober through a program. Okay? And
Can I find one of those at a AA class?
yep, that's where you get the sponsor, the
Okay.
AA, NA, or CA. So there's Narcotics Anonymous, Alcoholics Anonymous. There's a number of different programs.
Mhm.
Probation has a list of them. So ones that I think are best are the ones usually held in or around churches. There are some locations that are less, say less positive because bad people hang around them and they will entice you to use. So I think probation has a pretty good handle, so does law enforcement on where those locations are. It's sad to say that that happens, but it does. So make sure you're going to a meeting where people aren't hanging around saying, hey, come over here, I got something for you.
Right. Yeah, I ain't trying to go back that way.
Yeah, so talk to probation about that. You will, when referred for any treatment, attend. I also want you to go to grief therapy, and as part of that, cognitive behavioral to learn to make better choices. But you've got to live your life now for you, and you need to deal with the grief of losing your mother. That's a pain that's not gonna go away, but it should get better, and I think you need to talk to someone who's not family. Okay, so there are people who specialize in that, and I think that will help you. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You'll obey all court orders and all orders or recommendations by all treatment providers, physicians, therapists, probation. Those become orders of this court. You will not have verbal, written, electronic, or physical contact with anyone housed in Michigan Department of Corrections or who is on probation or parole. If you find out that somebody is on probation or parole, as long as you're all in good standing, then you can be with that person. And it's very likely that you'll come across some of those people who are in treatment, and that's okay, as long as everybody's in good standing, but just let probation know.
Okay.
You will allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer if probation has reasonable cause to believe you're violating probation. You'll submit to drug testing and alcohol testing randomly as directed by probation and your treatment provider and your aunt. You'll report any arrest, police contact, loss of employment, change of residence to probation, including any personal protection order placed on you, if any, within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. If you choose to be gainfully employed, you will comply with the SSI rules. There is some provision that allows you to do some minimal work. I don't know what those rules are, but if you choose to be employed, you'll comply with that. You'll serve 365 days jail with credit for 170 days served. The balance is held. I can use any or all of that time while on probation. You will pay crime victims assessment in the amount of $130 and a state cost in the amount of $240. So that is a total of $334. You can take as much time as you want to pay that. I know you have limited income, so if you pay a couple of dollars a week or whatever you can afford, that's fine. I will not hold probation open for the state to get their money, but you should make reasonable efforts to pay that. I'm waiving fines, costs, attorney fees. I'm waiving, well, you've already paid Mr. White, but and I'm waiving probation oversight. I don't believe you have the ability to pay. And you'll not use any object as a weapon, no guns, no ammunition, no imitation of a weapon. You'll not be in the presence of anyone who has those items, and you'll not use any object as a weapon. If you end up needing marijuana or alcohol, if it's prescribed for anything, you'll use it only as prescribed and show that prescription to probation. You have 42 days to appeal and request appellate counsel. And counsel, you'll show him where probation is so he can make his first appointment and keep all appointments, correct?
Certainly will.
And sir, do you acknowledge receiving your appellate rights?
Yes.
And I know I've gone through this rather quickly, but probation is going to go over it with you in writing.
And Your Honor, I do have the nollie for 256168 FH, if I may approach.
If you would approach counsel, we'll make sure you get a copy of that as well.
Thank you.
For his signing it.
Okay.
We'll give you a copy of this now in just a moment. Would like to, sir.
We'll wait for the nally and then I'm walking down.
Yeah.
There's anybody else there.
We're going to get another email.
One more set.
It's it.
Autumn Hauser.
Probably shouldn't say it. Is it?
What about the Holt? Can you do Holt?
We have not done Holt, Your Honor. Mr. Feigelson is doing in another hearing right now.
So is that rescheduled?
That's gonna have to be rescheduled, Your Honor.
What time is Hauser?
It's, I think it's at 10:30? 9:30. Oh, no, it is 10:30.
10:30, page 3.
I see
Bob.
it.
Let me go get, let me
Mr.
find the
Johnson?
fence, hold on, Your Honor.
What about Jones? Oh, we sentenced him. What about this Carell? Final,
Which one?
Carell?
They're getting debate on time. No.
And I don't know where Attorney Johnson is at the moment.
Well, he was just here. Is there anything else we can take?
I don't see any other defense attorneys here, Your Honor, and I believe we've moved everything else at this point.
Okay. He was just here, so.
He was, I'm not sure where he went, I don't know if he's in the bathroom or what, but.
So that April 10th date, do you know which one is likely to go? Because it looks like there's two
Yes.
that are likely to go.
So, yes, there are two that are likely to go. It's most likely going to be either Mr. Perkins or it's going to be Deontay Chapman.
When next year?
So yeah, so that's Mr. Carell. Mr. Carell was here for a final pretrial / plea, but I don't see the defense currently, so we're gonna have to.
Who's in the hearing room? Who's in the hearing room?
Is that, yeah, that's Mr. Carell.
Okay, who's his attorney?
It's Sarah, I just saw, she probably went back.
Sarah probably went back to get a new date. Let me go
Okay.
see if she's still
We
back
can
there.
do
We
that.
can do that.
We're waiting.
We're ready to go on Carell, Your Honor.
I went out, oh, I didn't see.
This is docket 256681 FH, People of the State of Michigan versus Jonathan Carell.
You gotta unmute him.
I hit.
Sir, can you unmute yourself?
There should be an officer in there to unmute him. And Your Honor, can I approach with
Yes, this is.
the plea agreement and to be no contest, please?
We don't have time.
Okay.
We don't have time to do a plea.
It's.
I didn't know it was gonna be, we don't have time to do a plea.
A DV second and a possession.
Well, I don't know where Kareem is. We can move Kareem's. I don't know, Nancy, you
It's like
attend.
3 minutes till maybe.
No, you-
You had a hard shut off at me, it's like 3-2.
Yeah, but the officers are not coming until I think 12:30.
Right.
Huh?
I said right.
I don't know. You okay doing this, Nancy?
I guess, I'm just in pain, but
Well,
let's get
no,
through it.
I don't need to, I don't want you to.
Let's just get through it. I fell yesterday.
All right, I don't know. Where's the other one?
Still kicking.
You may be blue cream, I don't know where he went.
He's not muted anymore though.
He's not muted. Sir? Mr. Carthel, are you still here?
Yep. We can hear you, Mr. Carthel. We just need you.
Sir, we need to see you.
Hey,
All right. All right.
hello, can you hear me?
So,
Yes, we're good to go.
please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Have you taken any medication yesterday or today? Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with your attorney?
Yes, Your Honor.
And I understand there's going to be a plea today, is that correct?
Yes, Your Honor.
And it'll be a no contest plea, counsel, based on what?
Civil liability.
Okay, court would accept that as a reason. What is the offer, sir, on behalf of the people?
Yes, Your Honor, the plea offer in this case would be plea to both counts, that being count 2, domestic violence, second offense notice, and count 3, possession of controlled substances, specifically narcotics, less than 25 grams. We would be dismissing the habitual fourth offender status, and there is a Kilgore agreement for this sentence to be concurrent with his current NDOC sentence in 24-248-FH.
So there's no time in the Kilgore, just concurrent with the way he's serving now?
Correct, Your Honor.
Okay. Full, fair, accurate, and complete?
Yes.
Sir, is that full, fair, accurate, and complete? Is that what you understand as well?
Yes, Your Honor.
Thank you. And counsel, you're waiving reading the habitual in its entirety?
Yes.
And the court would note that count 1 was dismissed at preliminary examination as to the reading of count 2 and 3.
Yes, Your Honor. People of the State of Michigan versus Jonathan Decarius Carthel, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant, count 2, domestic violence, second offense notice, on or about August 5th, 2025, and including August 12th, 2025, at 1008 East Cesar Chavez, Lansing, Ingham County, State of Michigan, the defendant did make an assault or an assault and battery upon Robin Fiskins, an individual with whom he/she had a dating relationship contrary to statute. Take notice that the defendant is previously convicted of assaulting or assault and battery his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.181A on or about February 24th, 2025, and therefore, upon conviction, will be subject to an enhanced sentence under statute. This is a misdemeanor that is punishable up to 1 year and or $1,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. And count 3, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. On or about August 12, 2025, at 1008 East Cesar Chavez, Lansing, Ingham County, State of Michigan, the defendant did knowingly or intentionally possess less than 25 grams of a mixture of the controlled substance cocaine.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 2, domestic violence, second offense, is a misdemeanor punishable by 1 year and or $1,000 along with restitution to the victim for any personal or property damage, if any. Do you understand that?
Yes, Your Honor.
And count 3, possession of a controlled substance known as cocaine less than 25 grams is a felony punishable by 4 years and or $25,000, and there would be forfeiture of any contraband. Do you understand all of that?
Yes, Your Honor.
And do you understand that at sentencing, I will design whatever sentence to run concurrent with the sentence you're now serving, and if I do not do that, then I would allow you to withdraw your plea, and this matter would again go back to the pretrial stage. Do you understand that?
Yes, Your Honor.
However, if you violate the law between now and sentencing, I can sentence you consecutive, I can sentence you beyond your time. There's lots of things I can do because you would be violating your agreement. Do you understand?
Yes, Your Honor.
Now, I don't have a signed rights form. I'm just going to quickly go through your rights. You do have a right to an attorney, which I understand you understand because your attorney's been here for all hearings and proceedings and you consulted with her. And you have a right to a bench trial or a jury trial and the presumption of innocence. You are innocent until proven guilty beyond a reasonable doubt. And on any count, the people, because it is their burden, could not maintain that burden, that count would have to be dismissed. And you're waiving that by pleading. Do you understand that?
Yes, Your Honor.
You also would have a right to choose a defense if you wanted to and ask the court to bring witnesses, and I would do that for you, and then the people would be able to cross-examine them and any evidence you chose to bring. But you also don't have to do anything at all, including you can remain silent at trial and not have your silence used against you. In the event you chose to testify, which would be your right, the people would cross-examine you. Do you understand all of your rights?
Yes, Your Honor.
And you are giving up those rights by pleading. You understand that?
Yes, Your Honor.
And I understand this will be a no contest plea based on civil liability to both counts. Is that correct?
Excuse me?
I understand that this is going to be a no contest plea to both counts based on civil liability. Do you understand?
I don't understand civil liability. The end.
Civil liability means that if the victim in this case wanted to take you to civil court, there's criminal court, which we're in now. There's also civil court. If she wanted to file a suit against you, if you were to make admissions in front of me, they would simply use it in the civil court and hold you accountable there as well. So by doing no contest, if they chose to proceed with another case against you, they would have to use their own evidence and witnesses, whatever came forward. They could not use this plea, whatever you said here. Do you understand?
Okay, yes, Your Honor.
Okay, so as to count 2, domestic violence, second offense, how do you plead?
No contest.
As to count 3, possession of a controlled substance known as cocaine less than 25 grams, how do you plead?
No contest.
Have you pled of your own free will?
Yes, Your Honor.
And you did that after you spoke with your attorney?
Yes, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes, Your Honor. I just met my attorney, but yes.
Okay, but you agree with what she's talked to you about, she answered all your questions, and you feel like she's adequately represented you in this matter, is that correct?
Yes, Your Honor.
Okay. Court is in receipt of Lansing Police Department Incident Report 25-03456-1. It does indicate that these offenses occurred on August 8th, 2025. Well, actually, the felony information says on or about August 5th, 2025, but the report was first submitted August 12th, 2025. Does the information have it wrong, or is there another?
So the information, Your Honor, says August 5th through and including August 12th?
Not mine, but okay.
Oh.
Perhaps an amended one was filed. So, okay, it appears that August 5th through August 12th, 2025, but this report was first submitted on August 12th, 2025 at 1600 hours, and states that at approximately 1330 hours, officers were dispatched to a domestic assault at 1008 East Cesar Chavez. Defendant Carell was arrested in the county of Ingham, state of Michigan at that location. And he was advised that officers were investigating him for possible assault that occurred. And in the search incident to the arrest, officers found in the rear left pocket black marijuana cigarette tube, but inside the tube, what was located was a small clear plastic baggie of a brown powdered substance. So let's get back, I'm gonna get back to that. Now I'm looking at the report. The victim Robin, R-O-B-Y-N, Marie, last name Huiskens, advised that she has known defendant for approximately a month, that they had stayed together for extended periods of time in various hotels and had an intimate relationship in the past. They've been living together at 1008 East Chavez Avenue for approximately a week. And she advised that defendant would shove her with an open hand to the collarbone area while telling her to shut up and calling her a bitch. She stated that these incidents happened over 10 times during the span of the week. And that's why there would be the August 5th through August 12th, 2025 date. It also appears that, and perhaps counsel can stipulate that this is a second offense because he was previously convicted of that same offense. I don't have the previous date, maybe counsel can fill me in.
Your Honor, it would be February 24th of 2005.
So stipulated?
So stipulated.
Where? Thank you.
That wasn't the same offense. It was my baby mother.
Yeah, no, we're just, it's just for the factual basis. Yeah, we're not, yeah, it's fine.
I don't hit one.
Yeah, we just have to, because it's the second offense, so we just have to show that that this is the second one, that there was a previous one at a separate time. I now turn to the Forensic Science Division within the Department of State Police, laboratory number LS 25-1753. And it does indicate that there was a heat sealed plastic evidence bag containing a tan powder and also containing something else that looks like was not analyzed. But nonetheless, item 2 that had the knotted plastic bag containing the tan powder was analyzed, and it was 3.0657 grams, and it was identified as cocaine, a Schedule II drug. However, isn't this report saying that it was not a controlled substance?
There was a true narc that says it was
I'm sorry,
inconclusive.
there's what?
There was a true narc saying that it was inconclusive, so it was sent for the lab for further analysis, and that further analysis is that lab report that you just read.
So tell me this, yes, but it, does this say it's conclusive? Did I?
No, it says inconclusive.
So why is he pleading to something that's inconclusive?
That is a true narc, Your Honor. A true narc is a preliminary test.
Yeah.
It is sent for the lab for further evaluation, more in-depth testing, and
I
that's
get
when it
that.
came positive.
Where's the positive line in here? I'd like to see it.
Oh, in the lab report?
Yeah. So do we have a lab report that says positive? Because this isn't the one that says positive.
That one that has cocaine?
This one says not confirmed.
Your Honor, what did you just read in regards to the cocaine being
It says
Schedule 2?
the result, wait, is this where, because then it says supplemental information.
It was cookies.
Sir, I need you to stop
Do you want to go to
interjecting.
trial?
All right.
Says substances identified cocaine, Schedule 2, but then under it, usually there's something that says that it was confirmed, because this says as applicable within this report, the control status of a substance is reported as follows. Schedules reported when a substance is listed by name or chemical structure. Does that mean that you just listing it means they found it to be positive of cocaine?
What I'm seeing, Your Honor, on the test results is it says in paragraph 3, substances reported and identified were chemically identified consistent with ASTM E2329 and laboratory policy. And this was, as you can see in the results analysis, substances identified cocaine Schedule 2.
Okay. All right. You'll both stipulate that that was identified as cocaine based on that?
Yes, Your Honor.
Yes.
All right. Very weirdly written report as far as.
I would agree, Your Honor.
On behalf of the people, any additional questions?
No, Your Honor, the people are satisfied.
On behalf of defense, any additional questions?
Yes, no further questions, Your Honor.
And would you both stipulate that he didn't have any license or special permission or authority to have the cocaine?
The people would so stipulate, Your Honor.
Yes.
All right. Our counsel where promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No.
Is court compliant with the court rule?
You have, Your Honor.
Yes.
I find defendant's plea of no contest to be appropriate based on civil liability, and that plea as to both counts has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. Based on both reports, I find there are sufficient grounds to accept defendant's plea of no contest, which enters like a guilty plea, but it is not a guilty plea, as I explained to him. So therefore, counts 2 and 3 will enter the habitual fourth is dismissed in its entirety, along with any outstanding warrants, if any, would be recalled and dismissed. Do we have a sentencing date?
May 20th at 10:30.
So you'll need to cooperate with probation. I'll come and see you, and we'll talk about the very detailed pre-sentence investigation report at the time of sentencing. Any contraband that was seized is hereby forfeited.
Your Honor, just for clarification, does Mr. Carthel wish to appear in person for sentencing or appear via Zoom?
Sir, do you want to be brought to court for sentencing, or do you want to do sentencing like we're doing it now?
We can do it like this.
Okay, so you have a right to be with your attorney, so at sentencing or prior to sentencing, she'll talk to you about the pre-sentence investigation report, probably over Zoom. We'll see how that is, and then if you have questions for her during sentencing, we'll put you in a confidential breakout room, okay?
I got a question. How do I get a copy of that lab results?
Will,
My office will provide you a copy.
your attorney will get you a copy of everything,
Yeah,
okay?
because I never got anything from no attorney, so I just want some paperwork at least.
Okay, she's on top of it. She's gonna get you all the paperwork you need, all right, sir? And if she doesn't, let me know and I'll remind her.
Reminder, I'm not the attorney of record on this. I'll tell Jacob Raleigh, the attorney of record.
Okay, well, no, sir, do you want her to be your attorney, for sentencing, or would you like your other attorney, Jacob?
Well, he's never met him.
He's never met him before you? Okay, then I'm not, no, you, sir, counselor, you are his counsel. We're not gonna do this. He's not met the other guy, so you are now counsel for plea and sentencing.
Okay.
Thank you.